next case to come before the court is Leibowitz versus State Farm Insurance. Was it Leibowitz?
Leibowitz, Your Honor, yes.
All right, you each will have 15 minutes, and you may reserve up to 5 minutes if you so choose. Just let me know, please.
Judge Carr, may it please the court, if I may, I would like to reserve 4 minutes for rebuttal.
That sounds good.
Thank you. As the court is well aware from the record and the briefs, this is a matter involving an insurance claim under a homeowner's insurance policy. I am privileged to be here this morning on behalf of Mr. Leibowitz, who is the homeowner who presented a claim for coverage. The court's also aware from the record that this involves the infiltration or intrusion of water into the front structures of Mr. Leibowitz's home back in 2012. There are really 3 primary issues presented on appeal based upon the findings rendered by the Common Pleas Court. The first relate to some fundamental coverage issues, which I'd like to cover and address to you first. The threshold issue of coverage is found in the coverage grant clause of the homeowner's policy at issue. Our position is that portion of the policy, at least, is pretty clear and unambiguous. And all that is required to trigger coverage is an accident which causes direct physical loss. Now, State Farm has taken the position that because of the nature of this water infiltration into the front of the home, somehow that is not accidental. It's important, I believe, for the court to note that the term accident is not defined in the policy with respect to the physical loss portion of the coverage. So as we have argued all along, accident simply needs to be given its plain and ordinary definition, which is fortuitous. There's no magic language, there's nothing mystical behind it. If an element of damage is fortuitous, not intended, not expected, not planned in some fashion, coverage ought to be triggered under the coverage grant of the policy. There's nothing in this record suggesting that somehow the water damage to the front of this house was anticipated, expected, planned, and thus in our view it was accidental. The next step, of course, is to look to whether or not there is evidence of direct physical loss. The record is replete with testimony about direct physical loss to the structures of the front of this house. Mr. Rorick, for instance, who was an expert witness called by the appellant, testified that he was called to investigate the conditions that Mr. Leibowitz had observed, and part of his investigation involved tearing off this EFIS structure from the front of the house, and the moment he opened those holes, he saw that there had been water infiltration and that the wood had begun to soak and was still wet at the time of his inspection. Moving on then, we need to focus on what was the reason, the primary reason that State Farm denied this claim. It was based upon provisions of 2 exclusions found in the homeowner's policy. Our position is that that is where the policy deviates and is no longer clear and unambiguous for it to be applied here. Most importantly, Your Honors, when you look at the provisions relied upon by State Farm, there is nothing in the language that refers to water damage or water infiltration or, frankly, water at all. Our position in the case is pretty simple. I kind of hate to use that phrase, but it's relatively simple when you look at the actual application of the policy. Our position is that water damage is a separate peril, separate and distinct from anything found in these exclusions. The words used in these exclusions deal with mold, fungus, corrosion, contamination, wear, tear, rot, those types of things. For whatever reason, State Farm chose to not use the term water in the exclusions relied upon in this case. How do we know from the policy, though, that State Farm recognizes water as a separate risk? We know that because separately in the policy are provisions dealing with water damages and when water damage is excluded from coverage under the policy. As we have briefed, and I don't need to elaborate too much this morning, but essentially when you look at those provisions, which I will stress are not relied upon by State Farm in the case, the limitations for coverage for the peril of water damage are very narrow and very limited. It involves things such as flood, surface water, waves, tidal water, tsunami, and those types of things, as well as waters percolating from under the ground. So again, on the applicability of the exclusions relied upon from State Farm, it's our position that because State Farm recognized water damage as a separate risk or peril, did not include it in the exclusions relied upon here, that the water damages sustained to the Leibowitz home should be afforded coverage. Much has been said in the record about, well, what is rot and what is water damage and how in the world does anybody draw any distinction. I think the most important parts in the record are, first of all, recognizing that the State Farm representative that investigated this case and testified at trial admitted at page 162 and 163 of her trial testimony that in fact she did observe what could properly be characterized as water damage to the Leibowitz home. In fact, she is in writing in one of her notes in her claim file that was addressed to her in the testimony, quote, "There is evidence of water damage around on the front door, on the interior and exterior." And she admitted that yes, that was her own observation recorded in her notes in the investigation of this claim. Now, at trial, of course, they tried to stress that this was rot or wet rot or dry rot, terms that are also not defined in the policy, I should add. And what's important about the testimony at trial is that State Farm applies rot, whether wet rot or dry rot, as being the total deterioration of materials. That's from the record, and it's very clear. And if you accept that as being State Farm's applicable test for whether or not the damage for which coverage is sought is rot, it's not satisfied here. The photographs admitted in the evidence indicate that there are very little, very minimal areas where there is material actually missing from the wood structures at the front of this home. Rather, the primary issue was the fact that when this home was opened up, it was still wet. And wet materials, wet wood materials in the front of the house are themselves damaged and need to be replaced. I need to move on to use the rest of my initial time to address the remaining issues, if I may. The next issue, of course, deals with the timing of the filing of the lawsuit. It's our position that indeed Mr. Leibowitz's suit was timely under the one-year contractual limitation clause found in the policy. As you know from the briefs, we rely upon two different points. Number one, that the record from Mr. Leibowitz is that he observed new or different or distinct elements of water damage at the end of June of 2012. I believe the record is that he described some staining or other indications of water on the front foyer of his house. He did the right thing. He did what you would expect any ordinary insured and homeowner to do, saw that something was going on, reported that to his insurance agent, and then hired someone, Mr. Rorick, to come out and open up and see what in the world, if anything, is going on in the house. So our position is, from a factual standpoint, that it is the June event that triggers this particular claim and the damages for the front of this house, and that the suit filed on the 28th of June in 2013 was timely. The other element of this issue, of course, deals with our estoppel argument. The record is very clear that when State Farm investigated this case, State Farm had an assigned date of loss date for this matter, and it was June 30 of 2012. The testimony is also very clear that that never changed. There was never a suggestion by State Farm that some other date was actually the date of loss in this case.
Well, they argue that date was supplied by your client.
Which is true, and I accept, Judge, that because of his testimony supporting the fact that that's when he saw the first indication or manifestation of some damage, that that's the appropriate date for this claim. Determining a date of claim under the policy is not simply looking at when an event happens, it's when it's manifest. I believe that the language of the policy speaks to it's not complete until there's some damage or loss. So until something is manifest, there's no claim yet.
To that point, does the timeliness of the complaint filing turn on the relationship of the June, is it 2012?
Yes, Judge.
June 2012 discovery to the water issues in that same general area that had preceded that?
Oh yeah, it's very important, and I hope we've done a decent job explaining our position that there are two distinct events. One that happened, came to fruition in 2011 and was repaired into January of 2012, confined to the top portion of the front of the home, I believe it was the architect, and the name escapes me, I'm sorry, but the architect that testified in the case very clearly said that he did that work. He was the one who was called in to look at it, do the repair, and in his mind, that work was isolated to the top. It had nothing to do with any infiltrations below. The testimony on the infiltrations below is that it was tied to defects or things that happened, harm that occurred to the flashing details, and where, in fact, the testimony was that the closer you were to the flashing details is where the bulk of the water was in the wood. So our position is that, yes, it's very important to distinguish between what had happened previously and what was observed in 12 and that assigned date. And then my estoppel point is that when State Farm denies this claim, and the exhibit, of course, is in the record, it indicates to Mr. Leibowitz that their understanding of the date of loss is June 30 of 2012. There's nothing in this letter that somehow waters that down in some fashion. Hey, we're just relying upon that date from you, or we're just picking that out of the thin air. Also, having done insurance work for many, many years, typically if there's some question about the date, it'll either be identified in the denial, or they'll simply indicate a date of loss for record purposes only. This is nothing like that. This is clear in accepting that date of loss.
Well,
On the third
they
page.
had not been, excuse me, Graham.
Yes, no, Judge.
But they had not been notified in 2011, had they?
No, there was no claim.
no claim.
That's correct. This claim is isolated to the 12th. That's accurate, Judge. Yeah. And so our position is when State Farm then advises it's insured and the letter says, here's what the date of loss is, we're telling you that's what we believe it is, and we're telling you you have 1 year within which, from that date of loss, to file your suit, that it should be an estoppel applied to any inconsistent position taken by State Farm. Finally, and I know I'm getting a little ahead of my time, real briefly on the damage issues.
Yeah, you actually, I'm sorry, I was
Am I
listening so
over, Judge?
intently, you're going to start that, so if you want to just hold off, that's up to you.
Well, I'll take 1 minute
Okay,
of
that's
my
fine.
time. On the damage issues, it's again our position that because State Farm asserted that the damages were excluded by an exclusion, it was the burden on State Farm to provide for any apportionment if necessary. We offered and submitted evidence of what our total damages were, what were appropriate deductions based upon some improvements, and for repairs to the flashing itself to come up with the net of $88,000. If State Farm felt it was appropriate to actually apportion money out for actual rot that may be sustained by the record, it was their burden to prove that. I appreciate the additional time, Judge.
Thank you.
Morning, Your Honors.
Morning.
May it please the Court, my name is Robert Chudikoff. I represent State Farm in this action. There are 4 issues, as I see it in this case. One is whether the suit limitation bars this claim entirely. The second is whether or not this loss falls within the insuring agreement of the policy, i.e. whether it is an accidental direct physical loss. The third being whether any of the exclusions apply. In this case, there were 3: rot deterioration, defective design, and latent defect. And lastly, whether the plaintiff proved that covered damages had occurred. And if so, what amount was covered. There's one very overriding important fact here that isn't mentioned by the appellant. This case was tried. There were experts who testified live. The magistrate judge heard those experts, saw the exhibits, observed the credibility of the witnesses, and made decisions on who to believe and who not to believe on issues like, when did the loss occur? Was in fact the prior damage and water stains repaired? Was it a separate event? These are all factual questions determined by the magistrate judge. Then affirmed, first they were determined by the experts, then they were confirmed by the magistrate judge. Then there was an oral hearing in front of the trial judge who accepted all of those findings as being based on credible evidence, competent, credible evidence. The standard of review on findings of fact, including on the 1-year suit limitation, this is why the trial court denied summary judgment to both parties on the issue of the 1-year defense, because it was unclear as to when the loss actually occurred, and the application of the 1-year defense turns on when the loss occurred. It does not turn on when the loss was discovered, and it most certainly does not turn on when the plaintiff discovered the extent of the loss. It turns on the occurrence of the loss. And in this case, the facts are that the loss occurred long before 1 year prior to suit filing, and the plaintiff knew it. And there was a ton of competent, credible evidence in the trial record upon which both the magistrate and the trial judge could find that that finding was sustainable. In fact, in this case, all of the competent, credible evidence that was presented at trial indicated that the loss and damage occurred more than 1 year prior to suit being filed. What was some of that evidence? The plaintiff testified that as early as 2005 and no later than 2007, he saw water stains on the walls and in the foyer area. He testified those stains returned every 2 years. He testified that he never conducted any investigation on what the actual cause of those stains were. He simply covered them up. And he didn't report them to the insurance company because they were far less than the repairs didn't match his deductible, so there was no claim. He replaced, in sometime prior to June 2012, a rotten beam that held up the skylight in the foyer area that he testified he was told was so rotten that if he didn't replace it, it was going to collapse. And in 2011, he noticed stains higher up on the wall in the foyer, and he had his architect, whose name is Anthony Luchetti, who designed the house, come in and look at the house and try and figure out what was going on. And he initially thought it was the skylight. He later determined the skylight was not the source of the water, but he never concluded that the damage he saw was different somehow than the damage that's being claimed in this case. To the contrary, he issued a report in which, and he testified at deposition and he testified at trial in this case, that this damage was rot and decay to the wood structural members of the house that occurred, that he saw on 3 different occasions prior to 1 year before suit was filed. July 7th, 2011, October 26th, 2011, and most importantly, January 6th, 2012. On that date, he took pictures. Those pictures were presented at trial as defense exhibits I-9 through I-16. They clearly showed rot and decay to structural members underneath the front wall of the house in January of 2012. All of this more than 1 year, this is 18 months prior to suit was being filed. The plaintiff knew this. There was tons of credible, competent evidence that this was an ongoing problem. It was consistent with their own architect's opinion, our structural engineer's opinion, that this was an ongoing, long-standing water problem caused by the defective design of this house, defective design, construction, or maintenance.
How did you rebut the other expert witness's testimony about the wet wood being observed in areas primarily in close proximity to the flashing, and then as you got further away from the flashing, you didn't see the damage?
He testified that you saw less damage, not that you saw no damage. And if I recall correctly, we rebutted it with the testimony of their own architect who designed the house and examined the damage. In addition to our own structural engineer, both of them testified that the water entry was caused by defects in the EFIS system and not through flashing damage caused by ice damming. And by the way, this whole ice damming argument, the magistrate found, based on that testimony, that even if it was ice damming, that had to have occurred over the course of many, many years, not 1 year prior to suit being filed. So even if you give them the ice damming, they still lose the 1 year defense because it would have occurred over a long period of time. It would not have met the definition of accidental, which is not an issue I've addressed yet. And these are factual matters that the trial court is permitted to find based on the testimony of the witnesses and the exhibits and the pictures that were shown and all of the evidence that was presented.
So basically this was a sort of a battle of the experts, and the trial court was within its province to decide which expert it found more believable.
That's correct. This is why we both moved for summary judgment and both lost, because the court felt there were factual matters that related to when the loss occurred and whether that was more than 1 year before suit was filed, at least on this particular issue. And it wasn't just the experts. The plaintiff's testimony about this history was relevant. And and his testimony about what he saw and when he saw it was relevant about whether he did know that there was an ongoing problem at the house long before 1 year prior to suit being filed. And that really was my next point. He never investigated the source or reported it to State Farm, but he knew about it long before June 30th, 2012, which is 1 year prior to the date of loss which is the date of loss that he reported to State Farm. And as to the estoppel argument, the plaintiff has to show reasonable reliance here. And it is pretty difficult for him to argue that he reasonably relied on a date of loss he provided when he had actual knowledge that the loss had been ongoing for years. It's simply not a credible argument, and it certainly doesn't meet the standard of reasonable reliance that he looked at a denial letter. There's no explanation for why he didn't report the loss for 3 months after June 30th or June 28th, June 30th, 2012. He doesn't call State Farm until the end of September.
What about just relying on the reason of denial? In other words, that you're not denying coverage, you weren't initially denying coverage on the basis of a time bar.
Well, we didn't deny coverage at all on the basis of a time bar. What we did was we provided notice that we were denying coverage based on these policy exclusions.
That's what I'm getting at.
Yeah.
That's my whole point. So why couldn't you reasonably rely on your insurance carrier when you're denying coverage, not raising the issue that there's a problem with the date of loss?
Because State Farm didn't establish the date of loss. Look at it from, I understand your point.
You don't have any duty?
I believe that State Farm has no duty to establish a date of loss so that the insured can trigger a time frame. The policy says you have to file within 1 year of the date of loss. Now, I do think it's State Farm's burden to show that the loss occurred more than 1 year, and we presented a ton of evidence to indicate that. I don't think we can just say it. In fact, the case they rely on, that's why it's distinguishable, because in that case, the insurance company just said it was the same loss as previous, and it wasn't the case. That was the Powdenar case, I think. This case is much different, and I think you have to look at it from his perspective. What did he know, and could he have filed suit within 1 year? The issue of estoppel or waiver on a 1 year, if you look at all of the body of cases, and they don't even cite the cases regarding waiver of the suit limitation, they all are based on whether or not the insured delayed filing suit because of something the insurance company did. They had Luketich report prior to the 1 year suit limitation being filed. They knew that the State Farm denied the claim in November of 2012. They filed suit in June 28, 2013. But the biggest point here is the actual knowledge of when the damage occurred. He can't get around the fact that he knew this was an ongoing issue, and that, or at least the court had enough evidence to conclude that he knew that. And so to say that we're stopped from asserting the 1 year defense when he had that actual knowledge, it's just impossible for him to establish that any alleged reliance he had was reasonable given that actual knowledge. And the issue is not whether, as I stated earlier, whether the full extent of the damage is known. It's whether or not the damage occurred. I think most of these other points on the 1 year defense I've covered. So I'd like, unless there are more questions, I'd like to talk just one quick point about the exclusions. This issue, fortuity on the issue of whether this is an accidental loss, is more than whether the loss was caused intentionally. A fortuitous loss is one that is, I don't know if there's a better word to describe it than fortuitous, because that word kind of sums it up. A tornado is fortuitous. Water damage resulting from defective construction is not fortuitous. It's the repairs necessary because your house was designed improperly. And the cases you read in our brief, there are a litany of cases that we cite in our brief that hold that this kind of loss is not what insurance policies were intended to respond to. It is certain that this kind of loss is going to occur when your house is constructed improperly. It is not fortuitous, and the cases that we cite say that. Secondly, you cannot, I want to read a short quote from Justice Friendly in a case that we cite on page 25 of our brief on this issue of water damage is not mentioned in the exclusion. The State Farm policy excludes rot and deterioration. These are types of damage, regardless of whether they're caused by water, mold, moisture, or any other cause. we don't cover these types of damages, and that's expressly stated. The Tennessee appellate case, the Phillips case that they rely on, completely, it involves a policy that doesn't have a rot exclusion or a deterioration exclusion like the present policy. And in fact, the court in the Phillips case says if it had, we would have a different outcome here. And that's exactly what we have in this case, a State Farm policy that expressly excludes rot and deterioration. Justice Friendly.
But you had more than rot and deterioration. I mean, you had just wet wood.
Well, but we disagree, and I think the trial court was within their ability to find that wet wood is not compensable damage. Our houses get rained on all the time. It's not until the water causes damage over a long, extended period of time. Wood gets wet all the time. Houses are built.
Wood in the interior, in the walls?
This is the structural members of the house, which are exposed during construction to rainstorms all the time. I mean, you build a house, the wood sticks are out in the open for several periods of days. They don't get damaged because wet wood isn't damage. If you expose it to that kind of moisture through water infiltration through a defective design over 20 years, which is what happened in this case, then you get rot and decay, and we don't cover that. And that's exactly how that issue played out in the trial court. Justice Friendly says, we do not think that a single phenomenon that is clearly an excluded risk under the policy was meant to become compensable because in a philosophical sense, it can also be classified as water damage. It would not be easy to find a case of rot or dampness or atmosphere not equally subject to that label, and the exclusion would become practically meaningless. That's exactly what's happening in this case. They can't call it design defect because it's excluded. And they can't call the resulting damage rot and deterioration because it's excluded. So they call it something that isn't excluded, water intrusion. The only Ohio case on this point was cited by us. It's a case called the Jewish Community Center versus St. Paul. It's a Northern District of Ohio case that's cited in our brief, and it's almost exactly the same situation. Failed to put a membrane under a shower in a locker room, and the water leaked out, caused all kinds of other water damage that resulted in decay and rot and similar types of damage here. And the JCC attempted to argue that it was water damage, which isn't specifically excluded anywhere in the policy. And the Northern District of Ohio said that it would defy common sense to consider the damage that resulted from the design defect as somehow a separate loss. It's all one event, and that's exactly what we have in this particular case. In particular, with respect to the damages, there's really only one issue here, and that's a burden shifting. They say that it's
Counsel, you're almost out of time if you want to sum up.
Okay. The burden of proof on damages is clearly for the plaintiff to prove what portion of his damages were covered. In this case, it was decay and rot, which were excluded, and anything else that he says is not decay and rot, which he claimed was covered. And if it was, then it was the plaintiff's burden to show what amount that was, not State Farm's.
And you're out of time.
Thank you, Your Honor.
Judge Garza, just a minute or two?
You have about 3 minutes.
3 minutes, all right, thank you, Judge. Two very important things. First of all, I heard from the appellee's argument that this entire case is tied to the issue of occurrence. This is not an occurrence policy. This is not a liability policy where typically you find the word occurrence is what's triggering your coverage. This policy only uses the phrase accident tied with direct physical loss. If you just have an accident, you don't have a claim. If you have your accident then coupled with direct physical loss, then you have your claim. The claim can't exist until it's complete, which is when some manifestation of damage is present. Here, the manifestation of damage was in June of 2012. I have no difficulty with the fact that the court needs to give some deference to the factual findings in the magistrate's decision. If you look, for instance, at the magistrate's decision starting at paragraph 90 under the findings of fact, you find that the magistrate concluded what Mr. Leibowitz understood about the prior water issues. Mr. Leibowitz understood that those issues were corrected prior to June of 2012 and testified he had no indication that there was any water infiltration below the skylight area. Immediately, the next paragraph under the findings of fact by the magistrate is based upon the Leukedic testimony that Leukedic testified that he did not expect at the time of the repairs in 2011 and early 12 any form of water infiltration or damage below the skylight. Leukedic believed then that water infiltration was isolated to the skylight, which was thought to have been repaired at the time. That's the state of the record on the timing of the event in June of 2012. When we look at the exclusions then, my final point would be with respect to the primary exclusions relied upon by State Farm. There is, in fact, clear distinctions in the policy between the risks that are covered or the forms of events that are covered in this policy. I'm not making these phrases up about perils. Peril is what's used in the State Farm policy. State Farm knows full well about perils from water damage, and as I addressed before, excluded it under very limited, narrow circumstances. In the exclusions relied upon here, there is no mention of water or water damage. At a minimum, the resulting damage clause of both exclusions is triggered to provide coverage for Mr. Leibowitz. We're not talking about seeking coverage for anything that relates to rot or deterioration or decay or wear or tear, or even the repair of the flashing itself. We're looking at receiving monetary compensation for the repair to the water damage that resulted from whatever source is demonstrated in the record. Even if you accept their position that there was something wrong with the EFIS installation and the water came in through the EFIS, for the same reasons addressed by the Phillips court, there's still coverage for the water damage that's resulting from that particular defect. So we appreciate your time and effort with this case and the extra time that you gave me this morning, Your Honor. And we appreciate the court, after thoroughly looking at this, reversing the judgment. We believe on the state of this record and the fact that de novo review is applied as a matter of law to the application of the policy language, that Mr. Leibowitz is entitled to judgment as a matter of law.
Thank you.
Thank you, ma'am.
Counsel. Thank you both for your presentations to the court. The court will will prepare a decision and send it out to both parties, as well as release on it. Thank you.
Very well. Thanks again.